arguments this morning, starting with State versus Tara Wells. Each party will have 15 minutes to present your arguments. The appellant may reserve up to 5 minutes for rebuttal. If you are going to reserve time, let me know and I'll keep track of that and try to keep you appraised of the time. The oral arguments are recorded, as both of you probably know, so we ask that you stay by the podium and keep your voice up. And we have read the briefs and are ready to proceed if you are.
Thank you, Honor. My name is Yumi Kim Reynolds. I'm here for Tara Wells. I would like to reserve 3 minutes for rebuttal.
3 minutes, okay.
You please support. In this case, Tara Wells' robbery conviction should be her conviction should be reversed because it was against manifest weight. Manifest weight of the evidence. They are just insufficient evidence to convict Wells. In this case, there were 2 different stories that were told. State would like us to believe that the 5 co-defendants who were involved in this case pre-planned all this. They talked about it, they planned it, they knew exactly what they were doing when they went to Walmart and got into Tara's vehicle. But I do not think that's what the evidence showed. Our argument is that Tara Wells didn't have any idea what was going on. She was told to be at the Walmart by her daughter. That daughter originally asked Wells, "Hey, I need to go to Walmart. Can you give me a ride?" And when Tara could not do that, Samantha Brown told Tara, like, "Oh, I'm walking over there, and I'm going to meet this guy, help him out," who Tara knew that was a very good friend of Brown's ex-boyfriend, who has tendency to be violent. So Tara Wells she was kind of worried about the safety of her daughter, so that's why she went to Walmart to kind of look out for her. Perhaps if something would happen, she can pick up Brown and then take her home, or if she needed a ride. And then this whole different thing, the scenario ensued, where they went over to Brown said, "We're going to my grandmother's house to get my ID," and Tara Wells and people in the vehicle followed Dylan and Brown in the vehicle, and Brown suddenly got out of Dylan's car and ran over to Tara Wells' vehicle, where Tara Wells did not have any clue what was going on. She just thought that there was, she always assumed that something's going to happen. Dylan was a bad person with maybe a problem. That's why she was there. And here comes Brown running out of Dylan Clark's vehicle, run to her vehicle, and here comes Dylan just running towards Tara Wells' vehicle, and he started to punch the occupants of the vehicle. Tara Wells just thought that Brown was getting robbed. So when she was told to go, she was the driver. She went. She drove forward to get away from the situation. Okay. That's what occurred. But as I said, Tara did not have any clue of, there was no plan. She just happened to be there trying to help her daughter. She observed something. She just assumed that certain things was going to happen, that was going on based on what her observation. She thought that she was protecting her daughter, and in the end, it turned out to be that way. During the case, I believe, Samantha Brown testified. Samantha Brown admitted that she had some mental health problems. She admitted that she has not been taking her mental health medications since September. I think this trial was in December. she was also, she testified that she was testifying that day against her mother because she's hoping to get some sort of consideration from the state on his case, on her case. She stated that she has known a lot of drugs between the incident and that December when she was testifying, that she could not remember a lot of things of what happened on June 27th, 2017. She did not remember, she testified she did not remember her talking to the police over the phone. She did not remember that she talked to Detective Smith. She said, she answered, I don't remember during this whole testimony like 20 times. She obviously did not remember what occurred on that day.
Well, she was called as a witness and began testifying. Was there any objection to her being called as a witness?
There was no objections to her being called as witness. However, it was clear during her testimony, it was clear that there were some issues with her competency. I understand that
so your argument is the courts should have just sua sponte stopped the trial?
That is correct. I know that there's case law that's they brought up here, State versus Kinney. I think this is the Court of Appeal, Ohio, Hamilton County, and this first district, 35 Ohio Act 3D84. It says that when it's clear that there are some issues in competency of the witness, it's not having in-camera review and to determine the competency of the witness is a plain error.
Now, what was it in this case that would have made it clear to the court?
The fact that she kept saying she didn't remember. I did not remember. I did so much drugs. I don't remember what happened. I don't remember that she or talking to police. I don't remember. She doesn't remember that she was talking to detective. There are a lot of things that she just didn't remember. She could not remember.
But wouldn't the jury see all that and be able to assess whether or not she was credible, or had the layperson would be able to figure that out in the jury?
In this case, I do not believe so, but because things like what were the medication were you taking was not. The defense counsel asked that. What are the mental health medication were you taking that you're not taking now? She wasn't allowed to ask that question.
But Schmidt was overruled, so she was allowed to answer that. So the question then is, defense counsel didn't pursue why she was taking medication or what kind of medication it was. Is that correct?
If that's the case, yes, she did not. If she was allowed to answer it, and she did not. If the defense counsel did not pursue it, yes. And Brown's testimony was very sketchy, and she said that I don't remember, and her testimony, the only part that implicated Tara Wells in Brown's testimony is at some point the state asked her, did you tell her about the plan of robbing Dylan? And her response was, yes, and that was it. There was no discussion about what happened, who did you tell, how did you tell, when did you call people, what were you going to do when you get there? Did you talk about Dylan? How much money did you tell them that was involved? Who's going to take how much? None of that was discussed during her testimony. Only thing that was talked about of Tara Wells' involvement prior to them going to Walmart is that Brown said, oh, I think I talked to my mother, not sure, but I told her that was it. And there was no other testimony in this case that says otherwise, that corroborate that testimony. No one talked about planning anything with anybody. The other person, I think that Chris Carson, also stated that he had no idea. He got into Tara Wells' car just because he was concerned about Brown being with Dylan. That's why he was there. There was no talk about robbery when he got into Wells' vehicle. That this was not pre-planned. Tara Wells testified in this case. Her testimony was a bit more credible. That she remembered details. She indicated that she remember getting phone calls from her daughter. She kind of ignored it. She had it with details of her testimony. She did admit that when the events were occurring, that in her back of her mind, she said, "This is not, something's going on here. This is not right. Something is going on here." She did not know what, but she did tell truth that she didn't try to hide it. That there's something was going on that's not all correct.
You're at 4 minutes right now.
We're just saying that there's just no credible evidence in this case that Wells knew about why she was being called to Walmart, what was going to happen. That Wells was very confused about what happened. Unfortunately, the victim in this case was hurt pretty badly. But there's just no credible evidence in this case against Wells. Another issue, like I said before, mentioned was the competency of Brown. The trial court should have stopped. When Brown was there and keeps saying all these things about, I don't remember, I did so much drugs, I'm not taking medication. It's clear that she's not capable of recalling what happened on June 27th. For all the good reasons.
Now you've got 2 minutes and 44. You want to reserve the balance of that?
Okay. Yes.
Okay. We'll give you 2 minutes and 44 seconds for rebuttal then.
Thank you.
15 minutes.
Good morning, Your Honors. And may it please the Court, I'm Vince Vellucci with the Medina County Prosecutor's Office for the appellee, the state of Ohio. I will start with the sufficiency of the evidence, which is basically that Wells did not know about this robbery. It's her knowledge that is really being disputed here. But the state actually presented a whole lot of evidence that Wells not only knew about her daughter's plan to rob Mr. Clark, but that Wells actually played a huge role in that plan. Wells' daughter, Samantha Brown, as was mentioned, she was sort of the star witness in the case, the co-defendant, the daughter of Wells. She obviously initially conceived this whole thing, and she testified to all that. Basically, she said that right after she agreed to help Mr. Clark send money to Walmart via this Western Union type thing, which was going to involve sending cash, she immediately called her mother, Wells, right after that, and she called her brother as well, who apparently got these Carson brothers involved as well. Samantha testified that she called her mother and her brother because she needed help, that she needed backup to rob Mr. Clark. That's why she called her. She testified that she did tell Wells the plan. Now, she didn't go into every single detail of what she told her, but she told Wells the plan. She told her mother the plan. She told her mother, Wells, that she wanted her to be there. Specifically, she told her to meet her at Walmart, and Wells did exactly that. what she asked. Wells drove to the Walmart parking lot where Wells actually came out at one point and spoke to her.
Well, there's a difference between meet me at Walmart and meet me at Walmart to help me rob somebody.
Yeah, and very true. And, you know,
Did she go further than just meet me at Walmart?
well, I think she told her that she said the entire plan in terms of robbing Mr. Clark, which involved, at the beginning, meeting at Walmart, and then following her from Walmart, which is exactly what happened, which she then gets into the car, Miss Samantha Brown gets into the car with Mr. Clark, and they drive away. Wells follows them. And then Samantha has Mr. Clark, who's driving. Clark is driving, she's in the passenger seat. She has Mr. Clark pull into a random driveway that she falsely tells Mr. Clark is her grandmother's house. And then she ends up with the money. She's holding the money because Mr. Clark has a cast and he's trying to drive, so he's got all this money. So he hands the money to her, which is exactly what she wants. When they pull into this driveway, she jumps out of the car. She first makes like she's going to go into the house, then she kind of turns around and she walks quickly out to the road where Wells is driving in her gold Toyota Camry at a slow rate of speed down the road. She jumps into the back seat at that point into Wells's moving car. Samantha testified in no uncertain terms that Wells knew about the robbery, that she was a part of it. In fact, she testified that after the robbery, when all these people, all these co-defendants, these co-conspirators went back to Chris Carson's apartment, Wells was actually the person who counted the stolen money. I know Chris Carson was mentioned. He was another compelling witness for the state of Ohio in terms of showing Wells's knowledge of this whole thing. He also testified that Wells knew about and was part of this robbery. Chris testified that when all the co-conspirators went back to his apartment after the robbery, Samantha and Wells were actually laughing together and talking about how they, quote, hit a lick when they robbed Mr. Clark. That's pretty well-known parlance for robbing somebody. Chris also testified that Wells counted the money, so he backs up Samantha on that, and he even adds that she passed it out to everyone. She's distributing everybody's cut from the robbery, is what Mr. Carson describes. In terms of manifest weight, the fact that Samantha and Chris both said they were hoping to get some kind of consideration out of this because they were co-defendants, that doesn't make their testimony any less credible or less reliable. That's pretty common that a co-defendant would agree to testify truthfully against another co-defendant in return for some consideration. Now in this case, Chris Carson actually testified that he had already pled guilty to robbery and he was awaiting sentencing at the time of his testimony. He testified that he was given no deal at all in terms of what his sentence would be. Samantha testified that she was just about to plead guilty to robbery and she already knew she was going to do 2 years in prison. That was her testimony. So that had already been decided before she ever testified for the state, before the state even knew what her testimony was going to be. So I think that pretty well disproves any notion there. Not that even if they said they were getting consideration, I don't think that would present a manifest weight issue. Wells testified in her own defense when we talk about weight, and she actually harmed her case quite a bit. Wells admitted that she was the person driving the gold Toyota Camry involved in the robbery. Wells admitted that while the incident was going on, she, quote, knew something wasn't right, speaking of her knowledge, but she, quote, didn't want to know about it. That's what she testified. Wells admitted that when they got back to Chris's apartment, she, quote, suspected something was wrong, yet she didn't tell any of her co-defendants to return the money. She didn't call the police. She didn't look into how Dylan Clark was doing after she just dragged him down the road with her car. In her testimony, Wells didn't dispute the fact that Mr. Clark suffered serious physical harm as a result of her actions. So really, and that's the testimony supposedly in her favor. So In terms of manifest weight, the evidence was not against the manifest weight of the evidence.
Was a defense of others a defense in this case? If it was, should it have been instructed?
It should not have been, and yeah, that was the fourth assignment of error here, and that would have to be an abuse of discretion. That instruction was requested by the defense.
Was not requested.
It was requested by the defense and denied by the trial court. That would have been completely inappropriate in this case, and it would have been error for the court to give that instruction. The evidence overwhelmingly established, as I just mentioned, that Samantha was at fault in creating this entire situation. This was all her plan to rob Mr. Clark that resulted in all of this whole incident happening. And because Samantha created the situation that gave rise to all this, and because she herself had no right to self-defense, and Wells stands in Samantha's shoes when you consider the defense of others, and whether that's appropriate. Wells was not justified in her use of force. Defense of others is not applicable. The testimony in terms of the punch, whether Mr. Clark, as he's jumping onto the side of the car and trying to reach and get his money back, he says he didn't punch anybody. So that testimony was disputed in terms of whether Mr. Clark threw a punch during this incident. It really doesn't make a whole lot of sense, though, that he did. As I mentioned, he was in a cast, and the hand that didn't have a cast, he was grabbing onto the car with. So, and Wells was asked this on cross-examination. So how in the world did Mr. Clark punch your daughter if he's got a cast in one hand and he's grabbing on for dear life to the side of this car with the other hand? How is he also throwing a punch? And she didn't have any response to that or any answer to that. But even if we accept that as true, that he did throw a punch, that wouldn't be anything approaching justification for what Wells did in terms of speeding up and dragging a barefooted man along the road, which resulted in horrendous burns to Mr. Clark's feet, as she's stealing from him, by the way. Samantha clearly wasn't in danger of death or great bodily harm, that's for sure. And like I said, the force of dragging him along the road was vastly disproportionate to any punch. I'll just touch on the alleged incompetency of Samantha Brown as a witness. As was mentioned, that was not objected to at trial. It wasn't objected to. Her competency wasn't objected to at trial, before trial. So we're looking at plain error here. There was not a plain error argument made in the brief, so that's really where I think the analysis should end there. But in terms of the merits, Samantha Brown did testify that she was arrested 3 days before Wells' trial. So 3 days before her testimony, there was a warrant out for her, and they had found her. She testified that at that time she was taking meth when she was arrested. However, she also testified that by the time of trial she had sobered up and she wasn't under the influence of anything as she was testifying. She'd been in jail for the last 3 days getting sober. So, and then to argue that she was incompetent just because she said a few times that she didn't remember when it came to some minor details, that's certainly not a grounds to find a witness to be incompetent. She actually testified in a whole lot of detail to a lot of things that happened that day. There were relatively minor details that she said she didn't remember. She did testify that she'd been off her medication since she was arrested. I know that was brought up earlier. But Samantha actually responded, "Not really," is what she said. When she was asked if that was affecting her ability to testify, she said, "Not really." And as was also mentioned, why she was taking the medication, what actual medication she was taking before she got arrested, none of that appears in the record. That was not followed up on by defense counsel in the questioning. So we don't even know what kind of medication we're dealing with here that she wasn't getting in this case.
So the record's not going to support bizarre behavior on the witness stand or anything obvious?
No, I don't think so. I don't think she was the easiest witness, but she did give a whole lot of, I think, clear and compelling testimony and detailed testimony about what happened that day. And clearly implicates her mother on several occasions, saying that she knew about this entire thing and was part of this, and from before till after she was part of it. She's counting the money. She's all these things. So and the details she didn't remember were, I think you'll find in the record, were relatively minor details, and even just as a principal, saying I don't remember doesn't make you incompetent. That's something that's a very different thing. You've got to raise that, and you've got to have that determined generally before trial and things like that, or I guess it could be determined at trial, but that's got to be kind of judged separately. You have kind of maybe a separate hearing outside of the hearing of the jury, that whole thing, but it was never raised at the trial is the point. So we're talking about plain error. How much time do I have?
2 minutes and 20 seconds.
Well, I think that's about all I have. If there's no other questions, I would just ask this court to affirm the trial court. Thank you.
And counsel, you've got 2 minutes and 44
Thank
seconds
you.
for rebuttal.
Thank you, Your Honor. The state responded to that there's no problem with Ms. Brown's mental health issues because she said that that was not impacted, her not taking medication is not impacted by her testimony. And I don't think that's quite true because it was clear that Ms. Brown's behavior on the stand was really odd. When she was pushed that, hey, you don't remember, she got agitated and she finally blurted out and say, Mom, you know what we did. She could not give any details, but she had to implicate Wells. That's why she's there for. She's going to get consideration for. She doesn't have any details, so she blurts out, Mom, you know what we did. That's all. There's all. She shouted out. That's really odd behavior, bizarre behavior during the trial from a witness. Tara Wells is not. There's no dispute that Dylan Clark was hurt, and she admitted that there's something going on here. Truthfully, there's something going on. Something did not make any sense. That's why that she's not trying to hide anything. She's just told how she perceived the situation. In this case, defense of others, jury instruction should have been given. Clearly, during the trial, that was the topic. That was the defense in the situation. That Tara Wells indicated that she was there. She thought her daughter was endangered. That she was protecting her. Of course, that jury instruction should have been given.
Do you agree that it was not requested by defense counsel? Or
no, it was requested by defense counsel, I believe. Then the trial court rejected the request to do so. So that's my recollection of reading the transcript. So that instruction certainly should have been given. That she thought that her family member was in imminent danger for death or serious bodily harm. Testimony in this case, it was clear that Dylan Clark was in panic. He had his torso inside the vehicle and started to punch the occupants in there, including Brown. He knocked over her glasses. It wasn't broken, but it was such a force that he was able to knock her glasses out of her face.
Counsel, thank you. We're out of time. So I want to thank you both for your presentations today. The court will take the matter under advisement and issue a decision in due course. Of course, the clerk of courts will mail you each a copy of the decision on the day it is released. You can also keep an eye on the Ohio Supreme Court's website where the opinions also appear. Thank you both again for your arguments.
Thank you.